case before the Court of Federal Claims highlights how shifting requirements in an energy savings performance contract project sparked a costly dispute and what it could mean going forward. Here to walk through the case and the lessons from it is partner at Haynes Boone, Zach Prince. Zach, it's great to have you on.
Great to be here, Terry.
We're going to talk about this case, Siemens Government Technologies. But before we dive into the case and the court's decision, walk us through the basic premise here, which is about energy savings performance contracts. How do they work?
Sure. So the government, it has a lot of facilities around the country and around the world. Many of those facilities are a little dated, let's put it nicely, where they waste huge amounts of energy just because the infrastructure is built decades and decades and decades ago. So as part of a way to try to modernize and save energy, they've developed two different mechanisms that are the real workhorses of modernizing in this regard. There are what we're dealing with here, which are energy savings performance contracts, and then there are utility energy savings contracts, or UESCs. This is more of the former, not the latter, but those are really the two mechanisms. So the way that these work is there's an IDIQ that will be held by a number of energy savings companies. Here, Siemens is one of them. The interested agency will go out and ask for quotes to put together a preliminary audit, or a preliminary assessment, rather, which is really a high-level review of the federal facility and suggestion of ways that the government can save money and the cost of doing it. This always has to be not just cost neutral, but has to have an actual savings to the government. And that savings is passed on then to the contractor. The preliminary assessment is itself an expensive process, but it's not nearly as expensive as the next part of this, which is if the government is interested in the preliminary assessment, they'll ask for a investment grade audit, or IGA, which is part of the task order award for the work itself. That can be millions of dollars. I mean, it takes tons of engineering time and real work from the contractor, and work that sometimes doesn't always get compensated if there's no ultimate award.
So it sounds like there are a lot of ways that these projects could get derailed. What specifically went wrong in the Siemens case?
Well, it's hard to tell reading just from the court's decision, but it appeared that DLA, which was administering this large project at the Goodfellow Air Force Base in San Angelo, Texas, changed some requirements after they had already received the first round of the investment grade audit from Siemens. They seemingly changed a ton of the assumptions that were used by Siemens to calculate the actual cost savings. And as Siemens put it, required a full-scale investment grade audit to be conducted again with a number of iterations that ended up costing somewhere north of $2 million.
That change in assumptions is interesting because as I read the case, it was almost 2 years from the initial request to Siemens' submission of their audit. And so many things could have changed. Does that make these kinds of projects a risky proposition?
They make them complicated. And the agency really needs to be focused on getting these projects done, getting the investment grade audit to be based on facts, not things that could rapidly change, which is, I think, what happened here, so that they understand what they're getting or what they might be getting and can execute the project.
So Siemens brought the case in the Court of Federal Claims. What was their argument?
So as sort of the background to this, the IGA often is not compensated when there's not a task order. And companies know that this is a risk that they're taking. The preliminary assessment is almost never compensated unless there's a task order. So they know it's a risk. But this is an unusual case because of how many iterations they went through with DLA just to then have the project totally canceled with nothing. So they brought some pretty interesting challenges here. They framed this as a bid protest primarily, as well as a breach of contract. So there was a contract, this IDIQ, with a task order for the preliminary assessment. That's where they brought a contract claim under. They said the government breached its obligations to administer a task order for the work itself under that IDIQ. So That's a contract dispute. They also said this was a improper administration of a task order award process where the government breached implied obligations to proceed in good faith and breached a variety of other statutes that really weren't discussed in the case. But they framed it as both contract disputes and a bid protest.
Speaking with Zach Prince, he's a partner at Haynes Boone. How did the government respond to those allegations?
Well, the government just asked for the whole thing to be dismissed, which it it often does. The bid protest issues are the ones that they really focused on, and I thought were of particular interest for this case because it was really a novel approach to try to get compensation by Siemens. The government argued that there can't be a bid protest here under the court's bid protest jurisdiction because of what's known as the FASA task order bar. It is, there is some limit to the jurisdiction of the Court of Federal Claims to hear disputes, bid protest disputes involving task orders. They either have no jurisdiction anywhere to have such bid protests or they have to go to GAO. But that limit has been hotly disputed and the subject of several Federal Circuit decisions, and the government lost that claim here.
And what else did the court have to say about Siemens' creativity?
The court was more focused on the government's attempt to trap Siemens by saying that either if there's a contract, an express contract, then they can't bring an implied in fact contract, which is one of their arguments they had brought as a bid protest, essentially. But also the government said there is no express contract that gives rise to relief. So as the court put it, it's heads I win, tails you lose type argument the government's trying to make, and it wasn't going to pass muster here, at least. The government might ultimately prevail, but this is a very preliminary stage, and the court was not willing to dismiss here.
So as you look at this case, what lessons do you draw for agencies and contractors around these kinds of projects?
Yeah, it's really tricky, and I've dealt with several of these contracts before. The contracting agencies often just don't have money to fund the preliminary assessment and maybe don't have money to fund the investment grade audit either, everybody's hoping together that it will ultimately turn into a task order for the work. And these task orders might be massive, $50, $100+ million. We're talking about multi-year projects for modernizing large facilities. But you can't just proceed on hope. It always makes me as outside counsel nervous, but you as a government contractor or as a government agency, you have to have a good relationship with your contracted counterparts. And those relationships can really carry the day to get folks compensated when they otherwise might not have. You find money at the end of a fiscal year and you come up with some mod to make the contractor whole because you know you have to do business with them again and you appreciate the fairness of it. On the contractor side, you have to recognize that there is risk here. And if you're not going to get an actual written commitment from the government, and not just the government, of course, the authorized person from the government to fund one of these projects, you might be left holding the bag. So they can be lucrative projects for sure, but there is risk. And as always, the government has to proceed in good faith, which is Siemens' primary argument here is the government just kept shifting around requirements, ignoring the fact that it was going to cost millions to do that, and then tried to leave Siemens with nothing. But you have to proceed with these projects with eyes wide open.
You mentioned risk there, especially for the bidders, but it seems like there's risk for all the parties, and it's not always clear that the potential revenue down the line will offset some of that risk. Is there a better way to structure these kinds of projects that would help everybody in the long run?
That's a great question. And I'm not just stalling because it's really complicated and I don't know the right answer. This is a really interesting mechanism to fund these types of projects. And the government likes it because they're not really left paying for anything. Right? They save money and those savings pay the contractor ultimately. And even in the utility version of these types of contracts where it's structured a bit differently, it's still not coming out of present appropriations generally. It is a savings that the government's getting ultimately on its energy bills, and that's being passed on to pay for the project. That's a great way to do business. If the government doesn't have to actually pay for anything, they're not subject to ongoing appropriation problems, and they still can get what they need, that's fantastic. The problem is just at the outset of these projects, there are all sorts of complications that really need to be considered carefully by all parties.
I've been speaking with Zach Prince. He's a partner at Haynes Boone. Zach, thanks for bringing this case to our attention, and we'll look forward to the next step in its resolution.
Sure. Thanks for having me, Terry.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts.